Joining me, as noted, is Alan Dershowitz, Professor Emeritus at Harvard Law School. Professor Dershowitz, let me turn first to the question of the 7 who have been subpoenaed. They seem to fall in 2 categories. One is Senator Lindsey Graham, who is a lawyer, but he's a senator. The other 6 of them are lawyers who were representing the campaign or the President Trump. Does that make a difference? I mean, when can you subpoena someone's lawyer? Where's that line?
Well, you can always subpoena anybody. And then the question is, do they invoke lawyer-client privilege? The Justice Department has certain internal guidelines for when you subpoena lawyers, when you subpoena journalists, when you subpoena priests, when you subpoena spouses. All of those are subject to judicial review. So there's nothing inherently wrong with subpoenaing lawyers. It shouldn't be done if the goal is to get them to reveal lawyer-client privilege, unless they have very strong evidence that the lawyer-client privilege has been waived by what's known as the crime-fraud exception. But they have to have a lot of very good evidence of crime-fraud, unlike Judge Carter in California, who made his judgment based on no evidence at all regarding President Trump. So we'll wait and see what evidence they have and whether they try to break the lawyer-client privilege.
All right. Well, the attorney-client privilege isn't absolute in the sense that you can't help your client, for instance, commit a crime. I'm not saying that happened here, but there is that line. Am I right?
Yeah, the crime-fraud exception, it's broader than just you can't help them commit a crime. You can't even have discussions that are about them committing crimes. You are limited to giving legal advice, basically. And the lawyer-client privilege doesn't cover just general communications between 2 people, one of whom happens to be a lawyer. You know, you hear all the time, I'll give you $1, and then anything that I tell you will be confidential. That's nonsense for 2 reasons. First, you don't have to pay a lawyer for the privilege to apply. And second, just because you paid $1 doesn't mean it's privileged. The discussion has to be about legal matters. And obviously, if you're talking about committing a crime, it's not about legal matters. I once had a case where a guy called me in the middle of the night, a client, and said I was asked to pay a bribe in order to get something done. What should I do? And I said, well, you know what you should do. Otherwise, you wouldn't have called me. You know that if you're going to commit a crime, you don't call your lawyer and ask him advice as to whether to do it. I'm telling you, don't commit the crime. And I called the U.S. attorney, and we got the other guys, and we put them in jail, and my guy went free. But you have to be careful when you're a lawyer not to be involved in conversations that are criminal in nature.
At what point does a prosecutor have a good faith reason to go forward with impaneling a grand jury? What's the standard?
There is almost no standard enforceable by the courts. Prosecutors are a separate branch of government. They're part of the executive, and they have enormous discretion when to convene a grand jury. Of course, there are 2 kinds of grand juries. There are grand juries that are intended to take evidence to indict particular people. And then there are broader grand juries historically, which look into situations and circumstances. Now, the one in Georgia could fall into either or both of those categories. They could be looking at a general problem, but more likely they're looking at specific individuals. Now, when you get a grand jury subpoena, generally you're informed whether you're a subject, a target, or just a witness. And I don't know whether any of these people have received the designation of what their status is. Generally, if they're a target, they won't receive a grand jury subpoena. So generally, they would be a subject, which means the grand jury is just interested in getting information from them.
All right, let me turn now to the Arizona law. Department of Justice suing Arizona. They want to block a law which says that you must show U.S. citizenship to vote. Thoughts on that one?
Well, there are 2 issues. Number one, does a state have the power to, first of all, it's not to vote. It's to vote in federal elections, generally. Does the state have the power to limit voting to citizens? Yes, they do. And the second question is, does the state have the inherent or constitutional power to enforce its rules by asking for proof? Now, if the asking for proof turns out to involve invidious discrimination based on race or education or things like that, for example, of the poll tax cases or the literacy cases, obviously the federal government has the right to make sure that voters are not disqualified from federal elections, maybe even from state elections. But this is an interesting and difficult case, and it will really depend a lot on the facts. But the Justice Department is not right when it says this is a clear-cut violation of the statute. It is not clear-cut. It may end up being a violation of the statute, but that will only be determined after considerable litigation.
Professor Alan Dershowitz, once again, thank you, sir.
Thank you.